Tonight, we examine a case that once commanded national attention and then became part of British legal history. A single investigation, a single verdict, and a legacy that has endured for more than a century. The case of Isabella Bankes begins in Bayswater, London, in the year 1858. Bayswater in the 1850s was a rapidly expanding residential district on the western edge of the city, developed over the previous 2 decades to accommodate London's growing professional and merchant classes. The area had been transformed from open fields and market gardens into a network of white stuccoed terraces, garden squares, and lodging houses within living memory of many of its residents. Its proximity to Hyde Park and its position along the newly laid streets radiating from Paddington made it a fashionable, if not the most fashionable, address for those of moderate independent means, professional men, and unmarried women who required a respectable establishment in which to reside. The Great Western Railway terminus at Paddington had brought a steady stream of traffic and commerce to the district, and the population of the surrounding parishes had grown substantially in the years leading up to 1858, as new streets of stuccoed houses were subdivided into lodgings and let, floor by floor, to tenants of varying means. London itself, in 1858, was the largest city in the world, with a population approaching 3 million persons within the metropolitan area. It was a city of stark contrasts, in which grand new residential districts, such as Bayswater, existed within a few miles of severe overcrowding and poverty in other quarters. The year 1858 was, in fact, remembered in London specifically for what became known as the Great Stink, when an exceptionally hot summer caused the pollution of the River Thames to reach such a degree that the smell was reported to have driven members of Parliament from their chambers at Westminster. This event, occurring in the same year in which the events of this case began, prompted the construction of London's modern sewer system under the direction of the engineer Joseph Bazalgette, a project that would take more than a decade to complete. Bayswater, situated well to the west of the river and the worst affected districts, was less directly affected by the Great Stink itself, but the year remained one of civic anxiety about sanitation, disease, and the condition of the rapidly growing metropolis. Boarding houses of the kind found throughout Bayswater in this period served a specific social function. They provided a respectable, supervised living arrangement for unmarried persons of the professional and genteel classes, men and women who had sufficient income to maintain a private household, but who, for reasons of circumstance, employment, or simply preference, chose instead to take rooms under the roof of a landlady, dining at a common table and observing the customs of the house. Such establishments were common throughout the western districts of London and were considered entirely respectable, so long as the conduct of the lodgers themselves remained within the bounds that Victorian society expected. It was into one such establishment in Bayswater that a woman named Isabella Bankes had taken lodgings by the year 1858. Isabella Bankes was, at the time these events commenced, a woman in her early 40s, though the precise date of her birth is not established in the surviving record. She was unmarried, and she was a woman of independent financial means, a fact confirmed by the value of her estate at the time of her death, which was assessed at approximately £2,000, a considerable sum for a private individual in this period. This income appears to have derived from family or personal property rather than from any occupation, and it was sufficient to allow her to maintain herself as a lodger of respectable standing without the necessity of employment. The surviving record does not establish the names or occupations of her parents, the place of her birth, whether she had siblings, or the nature of her early education. These details, which might in another case be recovered from parish records, family papers, or later biographical treatment, are simply absent from the documentary record that has survived regarding Isabella Bankes, and no attempt is made here to supply them where they do not exist. What can be stated with confidence is that Isabella Bankes had, by 1858, reached middle age without having married, a circumstance that was not unusual among women of independent means in this period, particularly those whose financial situation did not require the security that marriage often provided for women without private income. She lived, as many such women did, as a lodger in a private household, subject to the customs and social oversight that such an arrangement implied, but retaining a degree of independence that came with her own income and the absence of a husband or father to whom she was required to answer. Her position in the Bayswater boarding house placed her in regular contact with other lodgers under the same roof, sharing meals, common rooms, and the ordinary daily intercourse of a household run on these lines. It was in this setting, in the course of the year 1858, that she made the acquaintance of a fellow lodger, a physician by the name of Thomas Smethurst. Thomas Smethurst was, at the time of this acquaintance, a man of approximately 48 years of age. He held a medical qualification and had, in the years prior to 1858, operated an establishment in Surrey known as a hydropathic establishment, a form of medical practice fashionable in this period that centred upon the therapeutic use of water treatments, including baths, wraps, and controlled regimens of hydration, for the relief of various ailments. Such establishments, often referred to by their patrons and proprietors as water cure establishments, had become popular across England from the 1840s onward, drawing upon continental practices and attracting patients who sought an alternative to more conventional medical treatments of the period. Smethurst's establishment was situated at Farnham in Surrey, and the census records of 1851 place him at Badshot, in that county, residing at that time with his wife, a woman named Mary Smethurst. The existence of this marriage to Mary Smethurst is a fact of central importance to the case that follows, and it was not, at the time, Thomas Smethurst made the acquaintance of Isabella Bankes in the Bayswater boarding house, a marriage that had been dissolved, annulled, or otherwise brought to a legal end. Thomas Smethurst remained, throughout the period of his acquaintance and subsequent relationship with Isabella Bankes, a married man under the law of England, bound to Mary Smethurst by a ceremony and a legal status that neither divorce nor separation had altered. Whether Isabella Bankes was aware of this fact at the time she began her association with Thomas Smethurst is not established with certainty in the surviving record, and the sources reviewed differ on this point. What is established is that a relationship developed between the two lodgers over the course of 1858, and that this relationship became sufficiently apparent, or sufficiently a matter of comment within the household, that Isabella Bankes was asked to leave the boarding house as a consequence of it. The precise circumstances of this eviction, including the specific objections raised by the landlady or by other residents, are not detailed in the sources available for this account. It may be stated, in general terms consistent with the social conventions of the period, that an unmarried woman's open association with a man to whom she was not married, particularly one who resided under the same roof, would have been regarded by many Victorian landladies as a serious breach of the respectability upon which such an establishment depended for its reputation and its custom. Whatever the specific conversations or complaints that preceded it, Isabella Bankes departed from the Bayswater lodging house in the course of 1858, her residence there having come to an end as a direct consequence of her relationship with Thomas Smethurst. The relationship between Isabella Bankes and Thomas Smethurst did not end with her departure from Bayswater. Instead, in December of 1858, the two of them went through a ceremony of marriage. This ceremony, whatever its outward form and whatever words were exchanged, was void under the law of England, since Thomas Smethurst remained legally married to Mary Smethurst at the time it took place. A marriage contracted by a person already lawfully married to another living spouse has no legal standing, and confers upon the second party none of the legal protections, inheritance rights, or social standing that a valid marriage would provide. Isabella Bankes, in December of 1858, therefore entered into a union that had the appearance of marriage, but none of its legal substance, a fact of which she may or may not have been aware, and which the surviving record does not resolve with certainty. Following this ceremony, Isabella Bankes and Thomas Smethurst took up residence together at a property known as Alma Villas in Richmond, Surrey. Richmond in this period was a genteel town on the River Thames to the southwest of London, long favoured by the professional and merchant classes of the capital for its healthier air, its riverside prospects, and its semi-rural character, while remaining within convenient reach of London itself by road, and increasingly, in this period, by railway. It was considered a respectable and pleasant place of residence, the kind of setting in which a couple presenting themselves as recently married might reasonably establish a household without particular remark from their neighbours. Alma Villas was one of a number of villa residences of this type constructed in and around Richmond during the period of its expansion as a residential suburb, offering a modest but comfortable standard of accommodation suited to persons of the means that Isabella Bankes and Thomas Smethurst between them possessed. It was at Alma Villas in the early months of 1859 that Isabella Bankes became pregnant. The surviving medical and legal record of the case establishes this fact without providing extensive further detail as to the circumstances, and it is stated here only insofar as it bears directly upon the illness that followed and the medical questions that would later be argued at trial. Shortly after this point, in the spring of 1859, Isabella Bankes fell seriously ill. Her illness was marked by violent and sustained vomiting, together with other symptoms of gastric distress, a pattern that alarmed those attending upon her, and that would, in the weeks that followed, become the central medical question of the entire case. As Isabella Bankes' condition worsened through the spring of 1859, and as it became apparent to those around her that she might not recover, a new will was drawn up on her behalf. This will named Thomas Smethurst as the beneficiary of her entire estate, an estate valued at approximately £2,000. Isabella Bankes signed this will only days before her death. She died on the 3rd of May, 1859, at Alma Villas, Richmond, with Thomas Smethurst present in the household, in his capacity as her nominal husband and attendant carer. The doctors who had attended her during her final illness were sufficiently troubled by the pattern of her symptoms, the severity and persistence of the vomiting in particular, that they raised the suspicion of irritant poisoning, arsenic being the substance most immediately suspected given the clinical picture presented. This suspicion, raised in the days immediately following her death, would set in motion a formal post-mortem examination and a police investigation, the findings of which are addressed in what follows. If you value cases told this way, drawn from records rather than speculation, subscribe to the channel. And if you would like to read more of these stories, The Forgotten Women of Victorian Britain is linked in the top line of the description. Now back to the record. The circumstances that had brought Isabella Bankes to Alma Villas and to the illness that killed her there must be understood against the framework of Victorian marriage law as it stood in 1858 and 1859. The Matrimonial Causes Act had been passed only the year before, in 1857, and while it had introduced for the first time a civil process for divorce in England, separate from the ecclesiastical courts that had previously held jurisdiction over such matters, divorce remained in practice difficult to obtain, expensive, and profoundly damaging to the reputation of anyone involved in such proceedings. For a man in Thomas Smethurst's position, already married and established in a professional practice, a legal divorce from his wife, Mary Smethurst, would have required grounds, expense, and a public process that few men of his standing would have undertaken lightly. Bigamy, the contracting of a second marriage while a first remained legally in force, was a criminal offence under English law, but it was not in this period a rare occurrence. Cases of men maintaining what amounted to a second household presented to the world as a lawful marriage while a first wife remained living elsewhere, appear repeatedly in the court records of the mid-Victorian period, a consequence in part of the practical difficulty of obtaining a legal end to an unwanted first marriage. For a woman in Isabella Bankes' position, without the protection of a valid marriage and without close family connections established in the surviving record, the arrangement at Alma Villas depended entirely upon the goodwill and conduct of Thomas Smethurst himself, and upon the fiction that had been established before their neighbours and acquaintances in Richmond that theirs was a lawful union. The household at Alma Villas in the early months of 1859 would have followed the ordinary domestic pattern of a Victorian professional residence of modest but comfortable means. A married couple of this standing would typically have kept at least one domestic servant, responsible for cooking, cleaning, and the general maintenance of the household, and it is consistent with the record that such a servant or servants were present at Alma Villas during the period of Isabella Bankes' final illness, since it was household staff and attending medical men, rather than family members, who would later be called upon to give an account of what they had observed. Richmond itself, in this period, retained a population considerably smaller than the great mass of London. Its streets lined with villa residences set back from the road, its proximity to the river providing both a pleasant outlook and, in the warmer months, the particular smells and dampness associated with a tidal watercourse. The town had its own local tradesmen, its own resident physicians, and its own society of professional families, a self-contained community in which a new arrival such as Thomas Smethurst, presenting himself with his qualification as a physician and his wife at his side, would have found a ready place. Thomas Smethurst's professional background as a physician, and specifically his operation of a hydropathic establishment in Farnham prior to his removal to Richmond, placed him in a position of particular significance with respect to the events that followed. A hydropathic establishment of the kind Smethurst had operated required from its proprietor not merely a general medical qualification, but a working familiarity with the preparation, dosage, and administration of medicines. Since patients undergoing water cure treatments were frequently prescribed supplementary remedies alongside the baths and wraps that formed the core of the therapy. Smethurst's medical training and his experience running such an establishment meant that he possessed both the professional knowledge and, by virtue of his standing as a physician, the ready access to medicines and medical supplies that a layman in his position would not have had. This aspect of his background would become material to the case constructed against him in the months that followed Isabella Bankes' death, since it bore directly upon the question of both means and opportunity. The precise nature of the medicines that were kept in the household at Alma Villas during the period of Isabella Bankes' illness, and the manner in which they came to be administered to her, are matters that were explored in considerable detail during the investigation and trial that followed her death, and are addressed in the account of those proceedings. What may be stated at this point is that Isabella Bankes, in the weeks preceding her death, was attended by more than one medical man, in addition to whatever care Thomas Smethurst himself provided in his capacity as both her nominal husband and a qualified physician in his own right. This dual role, in which the man presiding over her sick room was simultaneously her domestic partner and a trained doctor capable of prescribing and administering treatment, was itself an unusual feature of the case, and one that the attending physicians, and later the investigating authorities, would regard with particular attention once suspicion of poisoning had been raised. The illness that overtook Isabella Bankes in the spring of 1859 began with symptoms that, at first, might have been attributed to a range of ordinary causes. She experienced episodes of vomiting that recurred with increasing frequency and severity over a period of days. Alongside this vomiting, she suffered from pain and distress consistent with disturbance of the digestive system, symptoms that confined her increasingly to her bed, and that alarmed those attending upon her sufficiently that additional medical opinion was sought beyond whatever care Thomas Smethurst himself was providing in the household. The pattern of her illness, marked by repeated and violent vomiting that did not resolve with rest or with the ordinary remedies of the sick room, was one that a physician of the period would have recognised as consistent with several possible causes, among them the effects of an irritant poison such as arsenic, but also, as would later be argued at length, the effects of complications arising from pregnancy, including the physical strain of persistent sickness upon a woman already in a delicate condition. As the illness progressed through its final days, Isabella Bankes' condition deteriorated to the point where recovery appeared increasingly unlikely to those around her. It was in this period, with her health failing and her strength diminished by the sustained vomiting she had endured, that the new will was prepared and brought to her for signature, the document naming Thomas Smethurst as the sole beneficiary of her estate. She died on the 3rd of May, 1859, in the household at Alma Villas, with Thomas Smethurst present. There was no witness to any specific act of administration of a substance to her in the days before her death. No servant or visitor who later testified to having observed poison being given to her by any hand. The case that would be built against Thomas Smethurst in the weeks that followed rested not upon direct testimony to an act of poisoning but upon the circumstances surrounding her illness and death, the timing of the will, and upon forensic examination of her body and of the medicines kept within the household. In the immediate aftermath of Isabella Bankes' death, the physicians who had attended her during her final illness were sufficiently troubled by what they had observed to raise their concerns with the appropriate authorities rather than allow the death to be registered and the matter to end there. Their unease centred upon the character of her vomiting, its violence and its persistence, and upon the coincidence of a recently altered will, naming as its beneficiary the very man who had presided over her sick room throughout the weeks of her decline. These were not the observations of laymen, but of trained medical men who had witnessed the progress of her illness at close hand, and their decision to voice suspicion of poisoning, rather than allow the matter to pass without further inquiry, set in motion the sequence of events that followed. Word of their concerns reached the police, and it was this initial medical unease, rather than any accusation from a family member or any confession or admission on the part of Thomas Smethurst himself, that opened the formal investigation into the death of Isabella Bankes. The investigation that followed her death proceeded with the urgency that a suspected case of poisoning, occurring within a household, presided over by a physician who stood to inherit the deceased woman's entire estate, was likely to attract. Officers were dispatched to make inquiry at Alma Villas, and steps were taken to secure the medicines, bottles, and other materials that had been present in the household during the period of Isabella Bankes' illness, since these were understood from the outset to be of potential evidential value. Thomas Smethurst himself was placed under suspicion at an early stage of these inquiries. His position as both the nominal husband of the deceased woman and the principal beneficiary of her estate making him, in the eyes of the investigating authorities, the person whose conduct required the closest scrutiny. He was, in due course, arrested and formally charged with her murder, a charge that would carry him, in the months that followed, to trial at the Central Criminal Court. The task of establishing whether Isabella Bankes had in fact been poisoned, and if so by what means, fell to the medical and forensic authorities called upon to examine her remains and the materials recovered from the household at Alma Villas. Chief among these was Alfred Swaine Taylor, Professor of Medical Jurisprudence at Guy's Hospital, and by 1859 the most prominent forensic toxicologist in England, a man whose testimony in matters of suspected poisoning carried an authority that few other medical witnesses of the period could match. Taylor was engaged to conduct the forensic examination central to the case, and it was to his laboratory that the specimens taken from Isabella Bankes' body, together with the numbered bottles of medicine recovered from the sick room at Alma Villas were delivered for analysis. Taylor's examination proceeded methodically across the specimens submitted to him. He tested the bodily remains of Isabella Bankes for the presence of arsenic and other irritant poisons, employing the analytical methods available to forensic chemistry in this period, chief among them the Marsh test, a procedure capable of detecting even minute quantities of arsenic within organic material. In the tissue of Isabella Bankes herself, Taylor found no trace of arsenic or of any other poison. This finding and absence of poison within the body of the woman whose death was under suspicion might, in another case, have brought the matter to a close. It did not do so in this instance because Taylor's examination of the numbered medicine bottles recovered from the household produced a different result. Among the bottles submitted to him, one in particular, referred to throughout the subsequent proceedings by its laboratory designation as Bottle 21, was found by Taylor to contain arsenic. This finding that a bottle of medicine kept within the household at Alma Villas and associated with Isabella Bankes' care contained arsenic, while her own remains contained none, became the central forensic fact upon which the case against Thomas Smethurst was constructed. The absence of poison in her body was explained, within the logic of the prosecution case, by the possibility that whatever quantity had been administered to her had been expelled through the violent and repeated vomiting that had characterized her final illness, leaving no detectable residue by the time a post-mortem examination came to be conducted. The presence of arsenic in Bottle 21, by contrast, was presented as direct physical evidence that poison had been present within the household and available for administration to her during the period of her decline. It was upon this finding, more than upon any other single piece of evidence gathered in the course of the investigation, that the prosecution's case against Thomas Smethurst would ultimately rest. The medical examination of Isabella Bankes' remains, beyond the toxicological testing conducted by Taylor, established that her death had resulted from the effects of her final illness, the sustained and violent vomiting that had marked its course, without the examining physicians reaching a conclusion as to the underlying cause of that illness that satisfied every party to the subsequent proceedings. The defence, when the matter came to trial, would advance an alternative medical explanation for her symptoms, one grounded in the physical complications that could arise from pregnancy, and, it was suggested, from purgatives that Isabella Bankes might herself have taken in an attempt to bring about a miscarriage. This alternative explanation was argued seriously before the court, and the surviving record does not permit a definitive resolution between the two competing accounts of what had caused her fatal illness, a genuine and unresolved medical question that ran through the whole of the case from its earliest investigation to its final disposition. The surviving record does not establish the details of any coroner's inquest that may have been convened in the days following Isabella Bankes' death, including the name of the presiding coroner, the date upon which such proceedings were held, or the verdict that may have been returned at that stage. What is established with certainty is that the matter proceeded beyond any preliminary hearing to a full trial before the Central Criminal Court, commonly known as the Old Bailey, Thomas Smethurst having been formally committed to stand trial on the charge of wilful murder. The trial of Thomas Smethurst commenced at the Central Criminal Court on the 7th of July 1859 before Sir Frederick Pollock, Lord Chief Baron of the Exchequer, who presided over the proceedings. The charge before the court was the wilful murder of Isabella Bankes by poisoning. Thomas Smethurst entered a plea of not guilty, and the trial proceeded before a jury drawn, as was customary, from among the propertied men of the city qualified to serve in such a capacity. The courtroom in which the trial was conducted would have been crowded, the case having already attracted considerable public attention in the weeks since Smethurst's arrest. The combination of a physician accused of poisoning the woman he had bigamously married, for the sake of an estate he stood to inherit under a will signed days before her death, providing precisely the elements that Victorian newspaper readers followed with close attention. The prosecution's case was presented across several days of testimony. Counsel for the Crown set before the jury the circumstances of the bigamous marriage between Thomas Smethurst and Isabella Bankes, the fact of his existing lawful marriage to Mary Smethurst, and the financial motive that the will, signed so shortly before her death, appeared to establish. Witnesses were called to describe the course of Isabella Bankes' final illness, the violence and persistence of her vomiting, and the household circumstances at Alma Villas during the weeks of her decline. The centrepiece of the Crown's case, however, remained the forensic evidence gathered by Alfred Swaine Taylor, and it was upon his testimony that the greater part of the court's attention and the greater part of the case's ultimate significance would come to rest. Taylor was called to give evidence of his examination of the specimens submitted to him, and he set before the court his finding that bottle 21, among the numbered medicine bottles recovered from the household at Alma Villas, had been found upon analysis to contain arsenic. He testified further to the absence of arsenic within the bodily remains of Isabella Bankes herself, offering the court his account of how such an absence might be reconciled with a case of poisoning, given the quantity of vomiting she was recorded to have suffered in the days before her death. This testimony, delivered by a witness of Taylor's standing and reputation, carried considerable weight with the court, and it may reasonably be supposed with the jury before whom the case was being tried. It was in the course of further questioning, whether upon cross-examination by counsel for the defence, or upon subsequent recall to clarify his findings, that Taylor was brought to make an admission that would prove to be of lasting significance to the history of forensic medicine in England. Pressed upon the reliability of his analysis, Taylor acknowledged that the arsenic he had reported finding within the contents of bottle 21 had not, in fact, originated in the bottle itself. It had come, he admitted, from the copper gauze forming part of his own testing apparatus, a component of the equipment used in the Marsh test that had, through contamination, introduced arsenic into the sample, being analysed rather than detecting arsenic that had genuinely been present within the medicine. The central forensic finding of the prosecution's case, the discovery of poison in a bottle kept within Isabella Bankes' household, was thereby revealed, in Taylor's own words before the court, to be the product of a flaw in his own laboratory procedure rather than evidence of poison placed there by any hand. Despite this admission, which struck at the very foundation of the forensic case that had been presented against him, the trial proceeded to its conclusion without the charge being withdrawn or the proceedings halted. The defence continued to press the alternative medical explanation for Isabella Bankes' final illness, presenting evidence and argument in support of the theory that her symptoms and death had resulted from the complications of pregnancy and possibly from purgatives she may have taken herself in an effort to bring about a miscarriage, rather than from any poison administered to her by Thomas Smethurst. Counsel for the defence set before the jury the absence of any witness to an act of poisoning, the flawed nature of the arsenic finding in bottle 21, and the alternative account of her illness, urging that the prosecution had failed to establish its case beyond reasonable doubt. The jury retired to consider its verdict following the conclusion of the evidence and the closing addresses of counsel on both sides. When it returned, the verdict delivered was one of guilty. Thomas Smethurst was found guilty of the willful murder of Isabella Bankes, notwithstanding the admission that had undermined the central forensic evidence upon which the prosecution's case had rested. Sir Frederick Pollock, presiding, proceeded to pass sentence upon the prisoner in accordance with the verdict the jury had returned. The sentence was death, the mandatory penalty prescribed by English law for a conviction of willful murder in this period, to be carried out by hanging. The verdict and sentence, once reported, produced an immediate and vigorous public reaction, a reaction that was, in its scale and its source, unusual for a case of this kind. It was not only the general public that voiced concern at the safety of the conviction, but the medical and legal professions themselves. Men who understood precisely what significance attached to Taylor's admission regarding the contaminated apparatus, and who regarded a capital conviction resting upon forensic evidence shown during the trial itself to be unreliable as a matter of the gravest professional and public concern. Petitions were raised, and correspondence addressed to the Home Office multiplied in the weeks following the trial, drawing attention to the flaw in the toxicological evidence and urging that the safety of the verdict be reconsidered before the sentence of death could be carried into effect. This professional and public campaign, mounted by doctors and lawyers across England and beyond, in the period between sentence and the date fixed for execution, was sustained and substantial, and it did not go unanswered by the authorities responsible for deciding whether the sentence should proceed. In response to this pressure, the Home Secretary took the step, unusual for the period, of referring the entire case to an independent medical authority for further review, rather than allowing the sentence to proceed or declining to intervene. The physician selected for this task was Sir Benjamin Brodie, a surgeon of considerable eminence and standing within the medical profession of the day. Brodie was asked to examine the medical and forensic evidence that had been presented at trial and to offer his opinion upon whether the conviction could be regarded as safe, given what was now known of the flaw in Taylor's analysis, and given the alternative medical explanation that the defence had advanced. Brodie's review proceeded over a period of weeks, during which Thomas Smethurst remained under sentence of death, the date fixed for his execution approaching, while the question of whether that sentence would in fact be carried out remained unresolved. Brodie's findings, once submitted to the Home Office, led to a decision that Thomas Smethurst should not be executed. He was granted a reprieve from the sentence of death, and this reprieve was followed, in due course, by a free pardon, the effect of which was to release him from the murder conviction entirely. The reasoning given by the Home Office for this decision, as reflected across the accounts of the case that survive, referred to the imperfection of medical science and the fallibility of judgment in an obscure malady, even among skillful and experienced medical practitioners, language that acknowledged the genuine difficulty of the medical questions at the heart of the case without declaring Thomas Smethurst to be innocent of the charge that had been brought against him. The pardon, in other words, reflected doubt as to whether the conviction could safely stand upon the evidence presented, rather than any finding that he had not in fact caused the death of Isabella Bankes. That distinction between a pardon granted for doubt and a declaration of innocence was one that contemporaries understood clearly, and it is one that the historical record of the case has preserved with equal clarity down to the present day. Following his release from custody upon the murder charge, Thomas Smethurst did not walk away from the courts entirely. He was brought before the court a second time on a separate charge, that of bigamy, arising from the ceremony he had gone through with Isabella Bankes in December of 1858, while his marriage to Mary Smethurst remained legally in force. This second charge presented none of the evidential difficulty that had attended the murder trial. The fact of his existing marriage to Mary Smethurst was not seriously disputed, and the fact of the subsequent ceremony with Isabella Bankes was equally beyond question, the two events together constituting the offence in the plainest possible terms. Thomas Smethurst was convicted upon this charge of bigamy and sentenced to a term of imprisonment, though the precise length of that sentence is not established with certainty in the surviving record. Upon the completion of whatever term of imprisonment he served for the offence of bigamy, Thomas Smethurst turned his attention to the estate of Isabella Bankes, the same estate that had been named in the will she had signed in the final days of her life, the will that had left the whole of her property, valued at approximately £2,000, to him. He pursued a civil claim upon this estate, asserting his entitlement under the terms of that document, and in this claim he succeeded. Thomas Smethurst, a man who had been convicted of her murder before a jury of his countrymen, who had been convicted separately of bigamy in respect of the very ceremony that had bound him to her, and whose innocence of her death had never been affirmatively established by any court or authority, nonetheless obtained the property that Isabella Bankes had left to him in the days before she died. This outcome was regarded by many of his contemporaries as a matter of considerable scandal in its own right, entirely apart from whatever view an individual might hold as to his guilt or innocence upon the original charge, since it meant that a pardon granted on grounds of evidential doubt had cleared the way for him to profit financially from the very death that had brought him before the court in the first instance. The subsequent course of Thomas Smethurst's life, following his successful claim upon the estate, including the place and manner of his later residence, the date of his death, and the location of his burial, is not established in the sources reviewed for this account, and no attempt is made here to supply details that the surviving record does not provide. The case of Thomas Smethurst and Isabella Bankes did not fade from public attention with the conclusion of the civil claim upon her estate. A detailed pamphlet account of the proceedings was published under the title The Case of Thomas Smethurst, M.D., His Trial, Sentence, Respite and Pardon for Wilful Murder and Prosecution for Bigamy, a work that set before the reading public the full course of the trial, the medical evidence, and the subsequent reprieve and pardon in a level of detail that reflected the intense professional and public interest the case had generated at the time. The trial itself was subsequently preserved within the notable British Trials series, a collection devoted to the documentary record of England's most significant criminal proceedings, ensuring that the transcript and surrounding material remained accessible to later generations of lawyers, medical practitioners, and historians. Papers relating to the case are held today by the Science Museum Group, a reflection of the case's enduring significance within the history of forensic and medical science rather than within the history of crime alone. That significance rests, above all else, upon the role played by Alfred Swaine Taylor and the error in his laboratory procedure that so nearly sent an innocent, or at the least an unproven, man to the gallows. Taylor was, at the time of the Smethurst trial, already established as the foremost authority on forensic toxicology in England, a reputation built over decades of practice and testimony that had earned him recognition in later assessment as a founding figure of British forensic medicine. The revelation delivered under his own testimony that his celebrated methods had produced a false result through simple contamination of his apparatus did lasting, if not permanent, damage to public and professional confidence in his evidence, a damage felt all the more keenly because it came from a man whose standing had until that point been regarded as beyond serious question. The case became, in the years and decades that followed, a standard reference point in discussions of the reliability of expert forensic testimony, cited repeatedly in the literature of medical jurisprudence as the clearest possible demonstration of how a flaw in laboratory procedure, undetected until exposed under the pressure of cross-examination, could very nearly produce a wrongful execution. The scientific method at the centre of Taylor's error, the Marsh test, had been developed some decades earlier as a means of detecting even the smallest traces of arsenic within organic material, and by the 1850s it was regarded as the most sensitive and reliable procedure available to forensic chemistry for this purpose. The test operated by converting any arsenic present in a sample into arsine gas, which was then passed through a heated tube where it decomposed to leave a visible metallic deposit, a method capable of revealing quantities of poison far too small to be detected by earlier chemical procedures. Its very sensitivity, the quality that had made it indispensable to the forensic investigation of suspected poisonings across England in the decades since its introduction, was also its greatest vulnerability, since a test capable of detecting such minute traces of arsenic was equally capable of registering trace contamination introduced by the apparatus itself, by the reagents employed, or by the materials from which the testing equipment was constructed. The copper gauze that formed part of Taylor's apparatus, and that proved to be the true source of the arsenic detected in bottle 21, illustrated precisely this vulnerability, a hazard inherent in the method that had not, prior to this trial, been so publicly and consequentially exposed before a court of law. Arsenic itself was, in the England of 1859, a substance of remarkable ordinariness and availability, present in households across the country for purposes having nothing whatsoever to do with poisoning. It was sold widely as a means of destroying rats and other vermin, a common and largely unregulated household commodity available from chemists and general dealers alike. It found its way into certain cosmetic preparations of the period, valued by some for the pallor it was believed to confer upon the complexion, and it appeared as a component in a range of medicinal preparations prescribed for various ailments, its therapeutic use in carefully controlled doses being a recognised, if increasingly scrutinised, feature of mid-Victorian medical practice. This widespread availability meant that arsenic poisoning, whether accidental, deliberate, or entirely absent, was a suspicion that arose with some regularity in cases of sudden or unexplained death throughout this period, and it meant equally that false accusations and mistaken suspicions of arsenic poisoning were not uncommon, the substance's ubiquity in ordinary households making its presence, in any given case, a fact that required careful and rigorous forensic proof rather than easy assumption. The particular anxieties of the period regarding arsenic had, in fact, already prompted legislative attention prior to the Smethurst case, and the substance's easy accessibility to any member of the public wishing to purchase it, whether for a legitimate household purpose or otherwise, remained a subject of continuing public concern throughout the middle decades of the 19th century. Against this backdrop, a case in which a physician stood accused of using his professional knowledge to administer a poison so commonly available and so difficult, even for a witness of Alfred Swaine Taylor's eminence, to trace with total reliability, touched upon anxieties that extended well beyond the particular circumstances of Isabella Bankes' household at Alma Villas. The Smethurst case placed before the public a demonstration of both the power and the fallibility of the forensic science, upon which an increasing number of criminal prosecutions in this period had come to depend, at precisely the moment when that science was beginning to assume the authority and prestige that would carry it through the remainder of the Victorian era and beyond. The case also stood as a demonstration of the particular vulnerability faced by a woman such as Isabella Bankes, a woman of independent means who had entered into a relationship without the legal protections that a valid marriage would have afforded her, and who had, as a direct consequence of that vulnerability, found her entire estate transferred by will to the very man later charged with causing her death. Her position, that of an unmarried woman of some financial independence, but without the family connections or legal safeguards that might otherwise have protected her interests, was not unique among women of her class and generation, many of whom faced comparable circumstances in an era when marriage remained. For most women, the primary mechanism through which financial security and social protection were secured, and the absence of a valid marriage left a woman such as Isabella Bankes to rely entirely upon the honesty and goodwill of the man to whom she had bound herself, however informally and however unlawfully that binding had in fact been made. The controversy surrounding Alfred Swaine Taylor's error in the Smethurst case did not end his career as England's leading forensic toxicologist, a position he continued to hold and from which he continued to give testimony in the years that followed. But it did leave a lasting mark upon the standards by which such testimony would come to be judged. Taylor's own published works on medical jurisprudence and poisons, works that had for years served as standard reference texts for physicians and lawyers throughout England, continued to be consulted and reprinted in the decades after the trial, yet the Smethurst case itself became a fixed point of reference within those very texts and within the wider literature of forensic medicine, cited as a cautionary illustration of the care required in the handling and interpretation of chemical evidence. Later editions of works on medical jurisprudence and the testimony of forensic witnesses, called in subsequent poisoning trials throughout the remainder of the 19th century, reflected a heightened awareness of the particular danger that contamination of testing apparatus could pose to the reliability of a chemical finding, an awareness that traced its origin directly to the admission Taylor had been compelled to make under questioning in the summer of 1859. The case contributed, in the years that followed, to an evolving expectation among the courts of England that forensic evidence of a chemical or toxicological nature ought to be subjected to greater scrutiny before being accepted as conclusive, and that the apparatus and methods used to produce such evidence were themselves proper subjects for examination and challenge by opposing counsel, rather than being treated as beyond question by virtue of the reputation of the expert presenting them. This shift, gradual and never formally codified in any single piece of legislation arising directly from the Smethurst case, nonetheless represented a meaningful change in the practical conduct of trials in which expert forensic testimony played a central role, one that later generations of legal and medical historians have traced with some consistency back to the events of 1859 and to the admission that Alfred Swaine Taylor made in open court regarding the copper gauze within his own equipment. The professional and public campaign that had been mounted on Thomas Smethurst's behalf in the period between his conviction and his pardon, a campaign sustained by members of the medical and legal professions who understood with particular clarity what the flaw in Taylor's evidence signified, was itself remembered in the years that followed as an early and significant instance of organised professional intervention in a capital case on specifically technical, evidentiary grounds, rather than on grounds of general clemency or sympathy for the condemned. It stood as a demonstration that a body of professional opinion, mobilised quickly and directed with precision at a specific evidential flaw, could succeed in halting the machinery of capital punishment even after a jury had returned its verdict and a judge had pronounced sentence, a demonstration that carried weight in subsequent decades whenever comparable questions of forensic reliability arose in other capital proceedings before the English courts. The case was entered into the historical record. It has remained there. The verdict stood. The case became part of British memory. The case of the first hour has closed. What follows is a quieter record, drawn from a different corner of London and an earlier year, concerning a woman whose death was never resolved, and whose story, decades on, would leave its mark on English fiction in ways its investigators could not have foreseen. The case of Eliza Grimwood begins in Lambeth, on the south bank of the River Thames, in the spring of 1838. Eliza Grimwood was known in the fashionable circles she moved through as the Countess, a nickname earned through the elegance of her dress rather than any claim to rank, and it is by that nickname, alongside her given name, that she appears throughout the surviving record of her life and death. London in 1838 was the largest city in the world, a metropolis of close to 2 million residents sprawling along both banks of the Thames, its growth accelerating under the pressures of industry, migration, and commerce. Queen Victoria had ascended to the throne less than a year earlier, in June of 1837, and the city she now nominally ruled was still, in most practical respects, the London of the preceding reign. Gaslighting had spread across the principal thoroughfares, but had not yet reached many of the side streets and courts. The railway age had barely begun. The Metropolitan Police, established in 1829 under Robert Peel, was not yet a decade old, and it possessed no dedicated detective branch. Investigations into serious crime were conducted by uniformed officers and by inspectors operating largely on individual initiative, without the institutional apparatus that would develop in the decades that followed. South of the river, the borough of Lambeth had grown rapidly in the preceding half-century, transformed from marshy fields into a dense grid of streets serving London's expanding population. The opening of Waterloo Bridge in 1817 had drawn traffic and commerce across the river, and Waterloo Road itself had become a principal artery linking the bridge to the theatres and places of entertainment that clustered on the Surrey side. The road was lined with shops, taverns and lodging houses, and by evening it filled with theatre-goers moving between the playhouses and their homes or their lodgings for the night. It was a thoroughfare that mixed respectable commerce with the less respectable trade that inevitably accompanied a district given over to evening entertainment. Wellington Terrace stood among the lodging houses of this district, a row of dwellings typical of the area, occupied by a mixture of tenants whose circumstances ranged from settled domesticity to more transient and irregular arrangements. It was in one such lodging at Wellington Terrace that Eliza Grimwood was residing in the spring of 1838, having established herself there as an independent woman with her own household, receiving visitors she had met in the course of her evenings at the London theatres. Eliza Grimwood had not been born to this life. The surviving record, drawn primarily from research conducted in the modern era by the historian Jan Bonderson, places her birth at approximately 1807 in the Suffolk parish of Stonham Aspel, a small farming community not far from the market town of Stowmarket. Her family had for generations worked the land as farmers in that part of Suffolk, a lineage of settled agricultural life stretching back well before her birth. At some point her father departed from farming and took up work as a bricklayer in the nearby town of Ipswich, relocating the family from the countryside into the more urban environment of a provincial county town. Eliza's early years followed a path common enough for a young woman of her background. At approximately 15 years of age, she left school and entered domestic service, taking a position as a companion to a young woman in a gentleman's household near her native parish of Stonham Aspel. The young woman she attended was lame, requiring companionship and assistance in her daily activities, and it was in this capacity that Eliza came to reside within the household. It was here, according to the record, that her situation changed irrevocably. The elder son of the family in whose household Eliza served began a relationship with her, and in the course of that relationship, she became pregnant. Rather than acknowledging the consequences of the affair within the community that had known Eliza and her family, the young man removed her to London, where an abortion was arranged. Having done so, he abandoned her in the city, leaving her without occupation, without family nearby, and without the position in domestic service she had previously held. This sequence of events, drawn from Bonderson's research and reflected in later secondary accounts, is treated in the surviving literature as the origin point of Eliza's subsequent life in London, and it is presented here on that basis, resting on that research rather than on multiple independent primary sources. Eliza did not return to Suffolk. Her family made attempts, according to the record, to persuade her to come home, but she remained in London, where her youth and her appearance gave her certain advantages within the fashionable demi-monde, the world of courtesans and kept women that existed alongside respectable London society in this period. She became in succession the mistress of a fashionable actor and later of an army captain, relationships that provided her with the means to acquire the elegant clothing that earned her the nickname by which she would become known. Whether these arrangements constituted settled domestic partnerships or more transient liaisons is not established with precision in the surviving record, but the pattern they formed was consistent, a progression from one relationship of financial dependency to the next, each conducted within the fashionable margins of London society rather than its respectable centre. By the time she took up residence at Wellington Terrace, Eliza Grimwood was living independently, supporting herself through relationships with men she met in the course of her evenings at London's theatres. Contemporary accounts of the period describe her occupation using the terminology of the time, identifying her as a woman engaged in prostitution, though the surviving record also makes clear that her manner of life occupied a broader spectrum than that single term suggests, moving between the fashionable status of a kept woman and the more direct commercial arrangements of the evenings she spent in the theatre district. It was a manner of living not uncommon among women in her circumstances in this period of London's history, and it placed her, on the night of the 25th of May, 1838, within reach of the man who would be the last person to see her alive. Living alongside Eliza at Wellington Terrace, or in close association with her, was a bricklayer named William Hubbard. Hubbard was a man who had lived apart from his own wife for some 12 years, and he was Eliza's first cousin, with whom she had lived as a domestic partner for nearly 10 years. What is established is that Hubbard was present in Eliza's household, or in close proximity to it, in the period leading up to her death, and that this proximity would later draw him into the investigation as a suspect. On the evening of the 25th of May, 1838, Eliza Grimwood was seen leaving one of London's theatres in the company of a man whom witnesses later described as foreign in appearance, well-dressed and gentlemanly in his bearing. He was noted to speak fluent English despite his foreign appearance, and according to some accounts, he was believed to be French or Italian, though his precise nationality was never established. This was not, according to the surviving record, a chance encounter between strangers. Eliza was understood to have been acquainted with this man for some months prior to that night, suggesting an established connection rather than a client met for the first time in the course of an evening's business. Together, the two departed the theatre and made their way south across the river toward Waterloo Road and Eliza's lodging at Wellington Terrace. It is here that the reliable record of that night ends. What occurred within the walls of Eliza's lodging after she and her companion arrived is not witnessed in any account that has survived. No one came forward to report having seen or heard anything unusual within Wellington Terrace during the night of the 25th into the morning of the 26th of May. The household proceeded, from the perspective of the surrounding community, as any other household might on an ordinary night, until the following morning brought the discovery that would draw the attention of the entire city. On the morning of the 26th of May, 1838, Eliza Grimwood was found dead in her bedroom at Wellington Terrace. The cause of death was a severe wound to the throat, sufficient to end her life, along with additional injury to her body that was likewise severe. The precise details of these injuries are a matter of record, but are not elaborated upon here beyond the fact that they were extensive and rapidly fatal. Her left thumb bore a cut, a mark that investigators at the time interpreted as evidence that she had raised her hand in an attempt to defend herself against her attacker. No weapon was recovered at the scene, and no witness had heard any disturbance from within the lodging during the night. The discovery of Eliza Grimwood's body brought an immediate response. Word spread quickly through Wellington Terrace and the surrounding streets of Waterloo Road, and the household in which she had lived was soon the focus of official attention. The circumstances of her death, a woman found in her own bedroom with her throat cut and no attacker apprehended, were sufficient to draw the involvement of the Metropolitan Police at a level beyond the ordinary. The investigation that followed would be conducted under conditions very different from those that later generations of detectives would take for granted, in a police force less than a decade into its existence, and without any formal branch dedicated to the investigation of serious crime. The man who took charge of the inquiry into Eliza Grimwood's death was Inspector Charles Frederick Field of the Metropolitan Police. Field was, at the time, one of a small number of officers whose reputation rested on individual initiative rather than institutional structure, since the formal detective branch of the Metropolitan Police would not be established until several years later. His investigation into the Grimwood case would become, in later decades, one of the better documented examples of how such inquiries were conducted in this early period of London policing, owing in part to the survival of Field's own case diary, a record of his work on the investigation that extended over several weeks following the discovery of the body. Field's investigation began with the household at Wellington Terrace and the immediate circumstances of the discovery. Statements were taken from those who had known Eliza, from neighbours in the surrounding lodging houses, and from any acquaintances who might offer information as to her movements on the night in question. The theatre from which she had departed with her unidentified companion was a natural focus of early inquiry, since it represented the last point at which Eliza had been seen in the company of another person before her death. Descriptions of the foreign gentleman who had accompanied her were gathered from those who recalled seeing the pair together, though these descriptions, consistent in their broad outlines, did not yield a name or an address by which the man could be traced. William Hubbard, given his residence within or in close proximity to Eliza's household, became an early subject of official attention. His relationship with Eliza, his own domestic circumstances as a man separated from his wife, and his presence at Wellington Terrace on the night of the murder made him a figure investigators could not overlook. Officers questioned Hubbard regarding his movements on the night of the 25th and 26th of May, and his account of those movements was recorded as part of the developing investigation, though at this early stage no formal action was taken against him. The investigation gained a further and ultimately unresolved dimension through the arrival of a letter addressed to those conducting the inquiry. The letter was signed by a person identifying himself as John Walter Cavendish, a name that does not appear elsewhere in the record as belonging to any established or verified individual, and which must be understood as a claimed identity rather than a confirmed one. The writer of the letter claimed to be the very man who had accompanied Eliza Grimwood home from the theatre on the night of her death, and he alleged in his letter that he had been attacked by William Hubbard in the course of that night. This claim, arriving as it did from an anonymous or pseudonymous source, placed William Hubbard at the centre of the investigation in a manner he had not previously occupied. Acting on the information contained in the letter, Inspector Field proceeded to arrest Hubbard, and the bricklayer was taken into custody to face formal questioning regarding his connection to Eliza Grimwood's death. The arrest represented the most significant development the investigation would produce in its opening weeks, and it briefly appeared to investigators and to the public alike that the case might be moving toward resolution. That resolution did not arrive. The author of the letter, signed John Walter Cavendish, never came forward to substantiate the claims he had made. No individual presented himself to investigators as the man described in the letter, and no corroborating evidence was produced to support the allegation that Hubbard had attacked or otherwise confronted the foreign gentleman on the night in question. Without the letter's author available to testify or to be examined, the claim against Hubbard rested on an anonymous accusation alone, a foundation the investigating authorities and the courts were unwilling to treat as sufficient grounds for a continuing prosecution. William Hubbard was brought before a magistrate to answer the allegations that had led to his arrest. This appearance before the magistrate was a proceeding distinct from the coroner's inquest that would separately examine the circumstances of Eliza Grimwood's death, concerned instead with whether sufficient evidence existed to hold Hubbard for further proceedings in connection with the murder. Having heard the evidence available, which amounted to little beyond the unsubstantiated letter and Hubbard's own proximity to the household, the magistrate discharged him for lack of evidence. Hubbard walked from the court a free man, and no further legal action was ever taken against him in connection with Eliza Grimwood's death. The discharge of William Hubbard left the investigation without a clear path forward. Inspector Field continued his inquiries in the weeks that followed, pursuing what leads remained available regarding the identity of the foreign gentleman last seen in Eliza's company. But the trail, never strong to begin with, did not strengthen with time. Field's own case diary, the record of his work on the investigation, is documented as concluding on the 14th of July, 1838, some 7 weeks after the discovery of Eliza Grimwood's body. In his notes, Field is recorded as having concluded that the most likely explanation for her death lay with one of two possibilities: either the unidentified foreign man who had accompanied her from the theatre, or William Hubbard himself, notwithstanding his discharge by the magistrate. Field reached no firm determination between these two possibilities, and the investigation, in the absence of further evidence, did not produce a definitive suspect. The examination of Eliza Grimwood's body was conducted in the days following its discovery, establishing the cause of death as the wound to her throat, which had severed the windpipe and proved rapidly fatal, together with the additional injury to her abdomen that was likewise noted as part of the examination. The individuals who conducted this medical examination are not identified by name in the surviving record available for this account, and their findings are known chiefly through the manner in which they were subsequently reported at the inquest into her death. The examination did not produce evidence that altered the direction of the investigation, beyond confirming the severity of the injuries and the manner in which death had occurred. An inquest was convened before the coroner to examine the circumstances of Eliza Grimwood's death, as was required under the law for any death attended by suspicious or violent circumstances. The specific date of the inquest and the identity of the coroner who presided over it are not established with precision in the surviving record consulted for this account, though the proceeding itself and its outcome are well documented. Witnesses were called to give testimony regarding Eliza's movements on the night of her death, her household at Wellington Terrace, and the discovery of her body on the following morning. The evidence presented to the coroner's jury included the findings of the medical examination and such information as the ongoing police investigation had by that point produced. Having heard the available testimony, the coroner's jury returned a verdict of willful murder against some person or persons unknown. This formula, standard in Victorian coronial practice for cases in which a death was clearly the result of criminal violence, but no perpetrator could be identified with sufficient certainty to name in the verdict, formally established the nature of Eliza Grimwood's death as murder, while leaving the question of responsibility entirely open. No individual was named in the verdict, and none has ever been definitively named in the historical record that has followed. No trial ever took place in connection with the murder of Eliza Grimwood. William Hubbard's appearance before the magistrate and his subsequent discharge represented the closest the case came to formal legal proceedings against a named individual, and even that appearance did not amount to a trial in the fuller sense, since no committal for trial resulted from it. The unidentified foreign gentleman was never traced, arrested, or brought before any court. The case, having proceeded through investigation and inquest, arrived at no further stage of legal process, and it has remained, from the summer of 1838 to the present, formally unsolved. The absence of any conviction meant that the questions raised by the investigation, chiefly the identity of the man who had left the theatre with Eliza Grimwood on the night of her death, and the exact nature of William Hubbard's account of his own movements that night, were never definitively answered. The record available for this account does not establish which of Inspector Field's two candidates' explanations, if either, reflected the truth of what occurred at Wellington Terrace. What remains is the documentation the investigation produced, the statements gathered from witnesses, the letter signed by John Walter Cavendish, the record of Hubbard's arrest and discharge, and Field's own diary, concluding without resolution on the 14th of July, 1838. The murder of Eliza Grimwood produced an extensive reaction within the London press of 1838, coverage that reflected both the sensational nature of an unsolved killing in a fashionable and well-trafficked part of the city, and the public's particular fascination with the unidentified foreign gentleman whose description circulated widely without ever yielding his name. The case was, in its own time, a significant event within London's crime reporting, discussed and speculated upon in terms that a modern reader would recognise as the forerunner of the sustained public interest that unsolved London murders would continue to generate throughout the Victorian period and beyond. It is in this respect that the Grimwood case has secured a form of remembrance quite distinct from many other unsolved killings of its era, resting less on the notoriety of the crime itself than on a documented connection to one of the most significant works of English literature produced in the years immediately following. Charles Dickens was, in the spring of 1838, in the midst of writing Oliver Twist, then being published in serial form in Bentley's Miscellany, a work whose composition therefore ran almost precisely concurrent with the murder of Eliza Grimwood and the investigation that followed it. Literary scholarship examining Dickens' sources for the novel has identified the Grimwood case, and Inspector Field's investigation of it as a probable influence on Dickens' depiction of the murder of Nancy at the hands of Bill Sikes, one of the most discussed scenes in the novel. The connection between the case and Dickens' fiction extends beyond Oliver Twist itself. Inspector Field, whose handling of the Grimwood investigation is documented through his own case diary, went on to a public career of some note within London policing, and in later years he provided Dickens with material and access relating to the work of London's detective police, an association that has led scholars to identify Field as a significant influence on the character of Inspector Bucket in Dickens's later novel, Bleak House. This connection between a real investigating officer and one of Dickens's enduring fictional detectives represents one of the more direct and well-documented instances of Victorian true crime feeding into the era's literature, and it accounts for the continued interest the Grimwood case has attracted among students of Dickens and of Victorian crime alike. The case has received modern scholarly attention in the form of a dedicated study by the historian Jan Bonderson, published under the title The Ripper of Waterloo Road, which draws together the surviving contemporary sources to reconstruct both Eliza Grimwood's early life and the investigation into her death in greater detail than had previously been assembled. It is from Bonderson's research that much of the fuller account of Eliza's origins in Suffolk and her path into the London demi-monde has become available to later readers, since the contemporary press coverage of 1838 concerned itself chiefly with the murder and its investigation rather than with the life that preceded it. The case also appears within broader surveys of Victorian London crime and within material produced for those tracing the history of London's East End and South Bank districts, generally cited as an early instance of the pattern that would recur across the following decades in which women working in London's sex trade became victims of violence that the era's policing proved unable to resolve. Eliza Grimwood's death occurred within the first year of Victoria's reign, at a moment when the young Queen's name had not yet come to define the era that would eventually bear it, and when the institutions that would later characterise Victorian criminal justice, a formal detective branch, an established system of criminal record-keeping, the broader machinery of organised policing remained largely undeveloped. The Metropolitan Police of 1838 operated without the investigative apparatus that later inspectors would take for granted, and the Grimwood case stands as an illustration of how an investigation proceeded under those earlier conditions, relying on the initiative of a single officer, the cooperation of witnesses, and whatever evidence presented itself, rather than on the more systematic methods that would develop in the decades that followed. The world in which Eliza Grimwood lived and died was one in which the boundary between fashionable society and the demi-monde she inhabited was porous but real, in which a woman of her background could move from domestic service to the position of a kept woman, and from there to independent life in a Lambeth lodging house, all while retaining the elegant bearing that had earned her a nickname suggestive of rank she did not possess. Waterloo Road's theatres and their evening traffic provided both her livelihood and, in the end, the circumstances of her death. A district built for entertainment and commerce that carried within it the risks attending any trade conducted after dark and beyond the notice of those who might otherwise have intervened. Wellington Terrace, the lodging house where she was found, remained afterwards simply another row of dwellings on a well-travelled Lambeth street, its ordinary appearance giving no indication of the case that had briefly made it known throughout London. The investigation was formally closed in 1838. No conviction followed. The case remains open in the historical record. Eliza Grimwood's Suffolk origins, though brief in the surviving record, offer a fuller picture of the world she departed than most cases of this kind allow. Stonham Aspel, in the early years of the 19th century, was a small farming parish in the Suffolk countryside, not far from the market town of Stowmarket, its economy built around the cultivation of grain and the keeping of livestock on the modest holdings that characterised this part of eastern England. The Grimwood family had worked such land for generations before Eliza's birth, a lineage of settled agricultural life that would have placed them among the respectable, if not prosperous, ranks of rural society. Her father's departure from farming to take up work as a bricklayer in Ipswich represented a shift common enough in this period, as the sons and heads of families whose land could no longer support them, whether through subdivision among heirs, rising rents, or the general pressures bearing on smallholders in these decades, moved into the towns to take up a trade. Ipswich, as a county town, offered building work of a kind the countryside did not, and the relocation of the Grimwood family from Stonham Aspel into that more urban setting would have marked a considerable change in the pattern of Eliza's early childhood, from the rhythms of a farming parish to the streets and yards of a provincial town. It was from this Ipswich household that Eliza, at approximately 15 years of age, was sent into domestic service, a step that was, for a girl of her background, entirely ordinary. Domestic service represented the single largest form of employment available to young women in this period, and a position as companion to a lame young woman in a gentleman's household, rather than as a scullery maid or general servant, would have carried with it a measure of status above the more menial forms of service. Such a position required a girl who could read, who could converse suitably, and who could be trusted in close and constant proximity to a member of the family she served. It was precisely this proximity, intended to provide companionship and assistance to a young woman confined by lameness, that placed Eliza within reach of the household's elder son, and it was that same proximity that would end her position in service and set her on the path toward London. The particulars of what followed, the seduction, the pregnancy, the abortion arranged in London, and the abandonment that came after it, are recorded in outline, rather than in the detail a fuller contemporary source might have preserved. But the pattern they describe was a familiar one in the social history of this period. A young woman in domestic service possessed few means of recourse against a member of the family that employed her. She could not easily bring a complaint without risking her own position and her reputation, and the family whose son had compromised her held every practical advantage in determining how the matter would be resolved. The son's choice to remove Eliza to London rather than address the situation within the community that had known her and her family reflects a common pattern of the era, an assumption that reputation could be preserved by distance, and that a woman's fate, once broken from the shelter of family and settled employment, was not a matter requiring further attention once the immediate difficulty had been managed. Having arranged for the pregnancy to be ended, the young man left Eliza in a city that held nothing of her previous life. No family, no position, no acquaintance beyond the man who had just abandoned her within it. London, in the early 1820s, into which Eliza Grimwood was delivered by these circumstances, offered a young woman in her position exceedingly few respectable avenues of support. She could not return to domestic service without a character reference from a previous employer, a document she was in no position to obtain given the manner of her departure. She could not easily return to Suffolk, where her family's efforts to persuade her to come home suggest that some door remained open to her, but where the same social pressures that had shaped the affair in the first instance would have continued to attach to her presence, a young, unmarried woman known to have borne the consequences of a liaison with her former employer's son. Between these two closed or difficult paths lay the world that Eliza in fact entered, the fashionable margins of London society in which a young woman's appearance and manner could translate into a livelihood, however precarious and however far removed from the respectability she might once have expected to inherit. The progression the record describes, from mistress of a fashionable actor to mistress of an army captain, and finally to independent life as a woman receiving visitors met in the theatres, followed a recognisable trajectory within this world. Actors of the period, particularly those attached to the more fashionable London stages, moved in circles that mixed genuine celebrity with a demi-monde of admirers, hangers-on, and women who attached themselves to the theatrical world, both for its glamour and for the financial support certain relationships within it could provide. An army officer, similarly, represented a category of protector common in the arrangements of kept women in this period, a man of some means and social standing who could provide lodging, clothing, and an allowance in exchange for a companionship that carried none of the obligations of marriage. It was through relationships of this kind that Eliza acquired the wardrobe and the bearing that earned her the nickname of the Countess, a nickname that marked her within her circle as a woman whose dress and manner exceeded what her actual origins would have predicted, and which followed her from these earlier relationships into the more independent phase of her life at Wellington Terrace. That independent phase in which Eliza received men she met at London's theatres, rather than relying on the sustained protection of a single, wealthy companion, represented a further step along the same path, one that placed her closer to the direct commercial arrangements that contemporary observers described using the terminology of prostitution, while retaining something of the fashionable bearing that had characterised her earlier relationships. It was a manner of living that depended on her continued youth and appearance, on her ability to move within the crowds that filled Waterloo Road and its surrounding theatres each evening, and on the discretion and comparative safety of a lodging house such as Wellington Terrace, in which a woman in her position could receive a visitor without drawing the immediate attention that a more public arrangement might invite. The theatres of the Surrey side, situated as they were within easy reach of Waterloo Bridge, and the crowds that crossed it each evening, formed the specific setting within which Eliza's evenings were spent, and within which she met the men who became her companions and her clients. These playhouses drew audiences from across the social spectrum, from fashionable visitors arriving by carriage to the more modest patrons who filled the cheaper seats, and the crowds that dispersed from their doors. Each night created precisely the kind of anonymous, shifting throng within which a woman such as Eliza could meet a stranger, form an acquaintance over a period of months, as she evidently had with the foreign gentleman last seen in her company, and bring that acquaintance home to Wellington Terrace without remark from her neighbours. The theatre district's economy of entertainment, refreshment, and lodging existed in close and largely unremarked proximity to the economy of the demi-monde that operated within and around it, two systems of commerce that depended on the same nightly crowds and the same hours of darkness. Waterloo Road itself, at this period, would have presented a scene of considerable activity each evening as theatre-goers made their way to and from the playhouses, as street vendors and cab drivers plied their trade among the crowds, and as the gas lamps that had by this date reached the principal thoroughfares cast their light along a street lined with shop fronts, taverns, and the entrances to lodging houses such as Wellington Terrace. The bridge itself, having been open for barely 2 decades by 1838, remained a comparatively modern structure within the city's geography, a toll crossing that had reshaped the relationship between the City of London on the northern bank and the Surrey side to the south, drawing commerce and traffic across the river in volumes the older crossings had not previously carried. It was across this bridge, in all likelihood, that Eliza Grimwood and her unidentified companion made their way on the night of the 25th of May, 1838, moving from the lit and crowded environment of the theatre into the comparative quiet of Wellington Terrace and the lodging that awaited them there. The household that received them at Wellington Terrace was one in which William Hubbard's presence, whatever its precise character, formed a constant backdrop to Eliza's arrangements with the men she brought home. A bricklayer who had lived apart from his own wife. For some 12 years, Hubbard was Eliza's first cousin and had lived with her as her domestic partner for nearly 10 years. What is clear is that his presence at or near Wellington Terrace was sufficiently established and sufficiently known to those in the surrounding community that investigators turned to him as a matter of course once the circumstances of Eliza's death became known, well before the arrival of the letter that would lead to his formal arrest. The task facing Inspector Field in the weeks following the discovery of Eliza Grimwood's body was considerable, given the tools available to him within a police force still in its first decade, and without any formal detective branch to draw upon for support or precedent. Field's approach, as reconstructed from his surviving case diary, proceeded through the patient accumulation of statements from those who might have observed Eliza in the company of the foreign gentleman, from theatre staff who might recall a well-dressed man of foreign appearance among their patrons, from neighbours at Wellington Terrace who might have noticed the pair arriving on the night in question, and from any acquaintance of Eliza's who might supply a fuller account of the months-long association she was understood to have had with the man in question. Each of these lines of inquiry required Field to conduct interviews individually, to record and weigh the resulting statements against one another, and to determine which details might be reliably pursued and which reflected only the uncertain recollection of witnesses describing a face glimpsed among a crowd leaving a theatre on a single evening. The description that emerged from these interviews of a man foreign in appearance, well-dressed, gentlemanly in his bearing, and fluent in English despite features that marked him as French or Italian in the eyes of those who saw him, was detailed enough to circulate through the press and through public discussion of the case, yet insufficiently specific to lead investigators to a name or an address. London in 1838 held a considerable population of foreign visitors and foreign residents drawn to the city by commerce, by the theatre and opera, and by the various professions that brought continental visitors to the capital, and a general description of this kind, however vivid, could not by itself narrow the search to a single identifiable individual. Field's investigation into this line of inquiry appears, from the surviving record, to have continued for some weeks without producing a name, a circumstance that left the case dependent on whatever further evidence might emerge from other quarters, including the household at Wellington Terrace itself. The arrival of the letter signed John Walter Cavendish must be understood within this context, as the first piece of evidence that appeared to offer investigators a direct account of events inside Eliza's lodging on the night of her death, rather than the second-hand descriptions gathered from theatre patrons and passers-by. A letter of this kind, purporting to come from the very man who had accompanied Eliza home, and alleging a specific act of violence committed against him by William Hubbard, represented precisely the kind of first-hand testimony that the investigation had, to that point, lacked. It is not difficult to understand why Inspector Field, presented with such a letter, proceeded to act on it by arresting Hubbard, since the alternative, to disregard a claim of this specificity without investigation, would have left a significant lead unpursued. The arrest of William Hubbard on the strength of this letter placed him under formal examination in a manner considerably more serious than the earlier rounds of questioning to which he had already been subject. Officers pressed Hubbard to account in detail for his movements on the night of the 25th and the early hours of the 26th of May, seeking to establish whether his own account matched or contradicted the narrative the anonymous letter had supplied. Hubbard, for his part, maintained his own version of events through this period of questioning, a version that the surviving record does not preserve in its particulars, but which evidently did not, in itself, provide grounds for holding him once the letter's author failed to materialise and substantiate the claims made against him. The failure of John Walter Cavendish to come forward is, in retrospect, one of the more significant unresolved elements of the entire case. A letter alleging a specific assault arriving at a moment of considerable public and official attention to Eliza Grimwood's death might have been expected to draw its author into the open, whether from a genuine desire to see justice done, from concern for his own safety should Hubbard, in fact, have been responsible for an attack upon him, or from the pressure of public interest in a case that was, by this point, closely followed in the London press. That no such individual ever appeared and that the letter's claims were never corroborated by any other witness or piece of evidence leaves open several possibilities that the surviving record does not allow to be resolved. The letter may have been genuine, written by a man too frightened or too compromised by his own presence in Eliza's company that night to risk further exposure by coming forward. It may equally have been a fabrication, composed by some other party for reasons the record does not preserve, intended perhaps to direct suspicion toward Hubbard for motives unconnected to any first-hand knowledge of the crime itself. Inspector Field's own notes, in concluding without a firm determination between Hubbard and the unidentified foreign gentleman, reflect the genuine uncertainty this unresolved letter left at the centre of the case. The uncertainty that closed Inspector Field's diary on the 14th of July did not close with it the informal judgment of those who had followed the case through the London press in the 7 weeks since Eliza Grimwood's death. A magistrate's discharge for lack of evidence carried, within the strict procedure of the law, a complete clearing of the individual concerned, entitling William Hubbard to walk from the court with no further legal obligation attaching to him, and no charge remaining on any record against his name. The surviving account of the case does not indicate whether this formal clearing was matched by an equivalent clearing in the eyes of those who had read of his arrest in the newspapers, or of those among his own acquaintance and trade who had followed the proceedings as they unfolded through the early summer of 1838. It was not uncommon in cases of this kind for a man once named in connection with a notorious killing to carry the association informally, long after the law had released him from it. His neighbours and his fellow tradesmen aware of his name from the newspaper columns, regardless of the outcome recorded in the magistrate's court. Whether this was Hubbard's experience in the months that followed his discharge is not established in the record consulted for this account, and no further mention of him appears in connection with the case beyond the proceedings of that summer. Field's own diary, in recording the conclusion of his formal inquiries on the 14th of July, reflects a working method characteristic of the investigative practice available to him in 1838, one in which a case was not so much closed as set down, its active pursuit suspended for want of further evidence, rather than terminated by any deliberate decision that the matter was settled. The 7 weeks spanned by the diary's entries had carried the investigation from the initial discovery of the body, through the gathering of witness statements, the pursuit of the foreign gentleman's description, the arrival of the Cavendish letter, the arrest and subsequent discharge of Hubbard, and finally to Field's own assessment, recorded in his own hand that the truth of the matter lay with one of these two figures, without his being able to say with certainty which. A diary of this kind, maintained across the working weeks of an inspector's ordinary duties, represents one of the earliest surviving examples of a documented investigative process from this period of London policing, preserved not because the case was resolved, but, in a sense, because it was not, since an inquiry that reached a clean conclusion had less occasion to generate the kind of extended written record that an unresolved case demanded of the officer still turning it over in the weeks after the trail had gone cold. The file that Field's diary and the accompanying witness statements comprised did not, with the closing of active inquiry in mid-July, disappear from the concerns of those connected to the case. Eliza Grimwood's household at Wellington Terrace continued its existence within the ordinary life of Waterloo Road, the lodging house itself untouched by the notoriety that had briefly attached to its address, its rooms in time occupied again by other tenants, as the practical necessities of London's housing market proceeded regardless of the events the building had witnessed. The theatres from which she had drawn her evening company continued to fill each night, with audiences arriving by the same bridge she and her final companion had crossed. The ordinary commerce of the district resuming its pattern within weeks of a killing that had, for a period that summer, made Waterloo Road a name recognised across the city. The days that followed the killing carried the case into the ordinary machinery of London newspaper commerce in a manner that the surviving evidence allows to be traced with some particularity. A murder occurring within a fashionable and well-frequented district involving a woman whose manner of dress had already made her a recognisable figure among those who moved through the Waterloo Road theatres, supplied exactly the combination the London press of 1838 was equipped to exploit at length, columns of type given over across successive issues to the discovery, the inquest, and each fresh development the police investigation produced. Readers who had never set foot in Lambeth came to know the name of Wellington Terrace through these accounts, and the description of the foreign gentleman, repeated from one report to the next, became a fixture of public conversation in a city where such conversation moved quickly between coffee houses, taverns, and the reading rooms where newspapers were shared among several readers rather than purchased individually by each. This pattern of sustained public attention placed a particular pressure on the investigation that a quieter case would not have carried. Every development Inspector Field's inquiries produced, the questioning of Hubbard, the arrival of the Cavendish letter, the magistrate's eventual discharge, became in turn the subject of newspaper report, so that the progress or the stalling of the case was conducted, in effect, before an audience considerably larger than the household at Wellington Terrace or the offices of the Metropolitan Police. Cases conducted under this degree of public notice carried an expectation of resolution that the private, unremarked killing did not, and the failure to produce a name to answer for Eliza Grimwood's death was felt, in the newspaper commentary the case generated, as a disappointment measured against the volume of attention the case had drawn, rather than against the more ordinary standard by which a quieter, unsolved killing might have been judged. The theatres from which Eliza had drawn her acquaintance did not escape mention in this coverage. Their proprietors and their evening audiences drawn into a controversy not of their making. Their names printed alongside a killing that had, strictly speaking, occurred at a considerable remove from their stages and their box offices. It was a feature of the reporting that the theatre itself, as an institution, bore no accusation. Its role in the case understood by contemporary readers as no more than the setting in which two individuals had first become acquainted, a circumstance common enough to countless respectable evenings that no suggestion of impropriety attached to the playhouses themselves on account of the killing that had followed one particular evening's performance. The murder of Eliza Grimwood was examined by an inspector whose own notes have survived, by a coroner's jury that returned its verdict in the customary formula reserved for such cases, and by a press that followed each development as it occurred. None of these efforts produced a name that could be entered against the crime with certainty. The theatre acquaintance and the household at Wellington Terrace remained, in the end, two possibilities set down side by side, neither confirmed and neither excluded. The case file was closed without resolution. No suspect was charged. The record remained as it stood. That is where the record of the second case ends. We turn now to the last of these three accounts, quieter still than the one before it, and set not among the tenements of a working district, but within the settled respectability of a Bloomsbury crescent, where a woman who had spent her later years in comfort was found dead in the one room of her house she might have expected to be safest. The case of Rachel Samuel begins in Bloomsbury, in the London borough that lay north of the British Museum and south of the Euston Road, in December of 1878. Bloomsbury by this date had already passed through several distinct phases of its history. It had been laid out in the late Georgian and early Victorian periods as a planned district of residential squares and crescents, built for professional and mercantile families who wished for the appearance of a garden estate within walking distance of the city and the West End. Burton Crescent, where Rachel Samuel lived, was one of these developments, a curved terrace of tall brick houses arranged around a private communal garden, its architecture reflecting the restrained classical taste of the period in which it had been built. By the 1870s, Bloomsbury as a whole had begun to change. Some streets and squares retained their original character as homes for settled, comfortable households, their occupants employing a cook, a housemaid, or a general servant according to their means. Other streets nearby had entered a slower decline, their large houses subdivided into lodgings and let by the room to a transient population of clerks, students, and visitors to the capital. Burton Crescent itself remained, at the time of the murder, a street of private houses rather than lodging houses, and its residents were understood to be people of settled means. It stood within a short distance of two addresses that had already acquired a grim reputation in the district, Euston Square and Great Coram Street, each the site of an earlier unsolved killing of a woman. The three addresses, considered together in the years that followed, gave this corner of Bloomsbury an association with unresolved violence that outlasted the individual cases themselves. The London of December 1878 was a city of more than 4 million people, the largest in the world, governed by the Metropolitan Police and served by a rapidly expanding railway and omnibus network that had, over the preceding decades, drawn Bloomsbury more closely into the daily rhythm of the wider capital. Gas lighting illuminated the principal streets and squares, though side streets and mews remained comparatively dark after nightfall. December brought the characteristic conditions of a London winter: short daylight hours, frequent fog thickened by coal smoke, and the ordinary domestic routines of a household preparing for the approach of Christmas. Within this setting, a household such as Rachel Samuel's would have kept to a familiar seasonal pattern, its rhythms governed by the comings and goings of tradesmen, the demands of the kitchen, and the presence or absence of servants employed to keep the house. The documentary record available for Rachel Samuel's early life is limited. Her date of birth, her place of birth, and the names of her parents are not established with confidence in the sources examined for this account, and the record does not permit a description of her childhood or upbringing. What can be stated is that by December of 1878, she was 74 years of age, a figure placing her birth in the first decade of the 19th century, during the reign of King George III, well before the accession of Queen Victoria. She had therefore lived through the greater part of the century, from its early decades through its middle years and into its final quarter, a span encompassing enormous change in the life of the capital in which she resided. The record identifies her as a widow, The name, occupation and circumstances of her late husband are not established, and this account does not attempt to supply them. What is documented is the manner in which she was living at the time of her death, and it is from these circumstances, rather than from any account of her earlier life, that the little that can be said of her must be drawn. Rachel Samuel was residing in December of 1878 at number 4 Burton Crescent, in a private house that she appears to have kept in the manner customary for a woman of her age and standing. The household had, at some point prior to the events of that December, employed domestic staff, since the person who would later come under suspicion in connection with her death was identified as a former servant of the house. It was not unusual in this period for a widow of comfortable means to live alone or with a single servant, maintaining a household on a reduced scale appropriate to her circumstances, while retaining the outward signs of gentility, a private residence, a settled address, and a small quantity of valuable possessions. The record indicates that Rachel Samuel possessed jewellery of some value, and that a sum of money, described in the sources as gold coin and banknotes, was kept within the house. These details, combined with her address in a respectable crescent, place her among the settled and comparatively comfortable residents of the district rather than among its poorer or more transient population. The record does not establish the specific circumstances of Rachel Samuel's final days, her visitors in the period immediately preceding her death, or the precise arrangement of her household staff at that time. What is documented is that a former servant of the house, a woman named Mary Donovan, would later be arrested in connection with the case, a fact that indicates the household had, within a period close to the murder, employed domestic help of the kind Mary Donovan is recorded as having provided. The exact date on which Mary Donovan's service in the household ended, and whether she had left under circumstances of any note, is not established in the sources examined, and the record does not permit speculation on this point. Domestic service was, in this period, the largest single category of paid employment for women in England, and a household of the kind Rachel Samuel maintained would have depended on servants for the ordinary functioning of daily life, the lighting of fires, the preparation of food, the cleaning of the house, and the answering of the door. A servant employed within such a household necessarily acquired an intimate knowledge of its routines, its valuables, and the movements of its occupants, knowledge that investigators of the period routinely regarded as significant when a crime occurred within a private house, and no sign of forced entry was recorded. It was this general pattern of Victorian domestic life, rather than any specific evidence described in the sources beyond her former employment, that placed a former servant within the circle of those whom the police would consider in the course of their inquiry. By December of 1878, Rachel Samuel was living in circumstances that gave her, on the surface, little reason to expect danger within her own house. She occupied a respectable address in a settled part of the capital. She was a woman of advanced years, 74, whose household, whatever its exact staffing at the time, had at some earlier point included the services of Mary Donovan. It was into this ordinary and outwardly secure household in an ordinary crescent of Bloomsbury that violence arrived in December of 1878, in a manner that the surviving record does not explain and that no subsequent investigation was ever able fully to resolve. The kitchen of a house, such as number 4 Burton Crescent, occupied the service quarters of the building, typically situated in the basement or ground floor rear, the domain in which servants performed the daily labour of the household, and in which a mistress of the house might pass through in the course of directing its affairs. It was in this room that Rachel Samuel was found to have met her death. The record states that she was beaten, the cause of her death established as the result of blows rather than of a weapon such as a blade or firearm. Consistent with the restrained treatment such findings are given in the account that follows, the injuries she sustained are not itemised here beyond the statement that they were severe and rapidly fatal, and that they occurred within the kitchen of her own house, rather than elsewhere upon the premises, or beyond them. The discovery of Rachel Samuel's body brought the ordinary machinery of Victorian criminal investigation into operation. The Metropolitan Police, whose jurisdiction covered Bloomsbury, would have been summoned to the house upon the discovery, and an investigation was formally opened into the circumstances of her death. Officers were dispatched to No. 4 Burton Crescent to examine the scene, to secure the house, and to begin the process of establishing what had occurred and when. The record does not preserve the name of the officer who first attended the scene, nor the precise hour at which the body was discovered, nor the identity of the person who made the discovery, and this account does not supply these details where the sources do not establish them. Statements were taken from those persons within the household and the immediate neighbourhood who could offer information as to Rachel Samuel's recent movements and associations. Neighbouring households in Burton Crescent, themselves occupied largely by residents of similarly settled and respectable circumstance, were canvassed by officers in the ordinary course of the inquiry, in the hope that some person might have observed an unfamiliar visitor to the house, or some disturbance in the period during which the murder was believed to have occurred. The record does not preserve the content of these neighbouring statements, nor whether any of them yielded information regarded by investigators as significant, and no account of a witnessed disturbance has survived in the sources examined for this case. Inquiries were directed toward establishing who had access to the house, and it was in the course of this line of inquiry that attention came to rest upon Mary Donovan, described in the record as a former servant of the household. A woman who had, at an earlier date, been employed within the house would have possessed knowledge of its arrangement, its hours and the habits of its mistress, knowledge that a stranger to the premises would not readily have had. It was this circumstance, rather than any specific evidence of presence at the scene described in the sources, that appears to have directed the investigation toward her. Officers proceeded to make inquiries as to Mary Donovan's whereabouts and her recent history since leaving the household service, and in due course she was located and taken into custody for questioning in connection with the death of her former employer. The arrest of Mary Donovan followed the ordinary procedure of the period, by which a person regarded as a significant suspect in a case of violent death would be detained and brought before investigating officers for examination, prior to any decision as to whether the case against that person was sufficient to proceed to a formal charge. The specific evidence that connected Mary Donovan to the scene of the crime, beyond her former position within the household, is not established in the sources examined for this account, and this narration does not attempt to supply detail that the record does not provide. What can be stated is that she was arrested, that she was questioned in connection with the death, and that the investigation that followed did not produce evidence sufficient to sustain a conviction against her. The question of what, if anything, had been taken from the house occupied a considerable part of the investigation, and it is here that the surviving record becomes least certain. Some accounts of the case state that a wedding ring, a small sum of coin, and a pair of boots belonging to Rachel Samuel were missing from the house following her death. Other accounts state that nothing whatsoever had been taken, and that investigators found this circumstance one of the more puzzling features of the case, since valuable jewellery remained upon her person, and a sum in gold and banknotes was left undisturbed upon the mantelpiece of the house. The record available for this account does not resolve this contradiction with certainty. It is possible that a small number of modest items were taken while more valuable property was, for reasons the investigation was never able to establish, left untouched. It is equally possible that the two strands of the surviving record describe the matter inconsistently. What can be stated without qualification is that a quantity of valuable jewellery and a substantial sum of money remained within the house after the murder, a circumstance that investigators of the period regarded as difficult to reconcile with an ordinary motive of theft, and one for which no explanation was ever established to the satisfaction of the inquiry. Officers engaged in the investigation would, according to the ordinary practice of the period, have examined the doors and windows of the house for evidence of forced entry in order to determine whether the person responsible for Rachel Samuel's death had gained access from outside the premises or had already been within the house, or had been admitted by Rachel Samuel herself. The record does not preserve the findings of this examination, and it is not established in the sources reviewed whether any sign of forced entry was recorded. In the absence of such a finding, and given the eventual direction of the inquiry toward a former member of the household staff, it may be inferred that investigators considered access without violence to be at least as likely an explanation as forced entry, though the record does not state this conclusion in terms, and this account offers it only as a reflection of the general logic that governed such investigations in this period, not as an established fact of this particular case. A post-mortem examination of Rachel Samuel's body was conducted in the course of the investigation, in keeping with the standard procedure required whenever a death occurred under circumstances suggesting violence. The examining physician is not named in the sources reviewed for this account, and the specific findings of the post-mortem beyond the general cause of death, the result of blows sustained in the kitchen of the house, are not preserved in the record available. The post-mortem findings would, in the ordinary course of proceedings, have been presented before the coroner at the inquest convened to determine the cause and circumstances of her death, and it is to be assumed that some record of that inquest existed, though the specific coroner, the date, and the venue at which it was held are not established in the sources examined, and this account does not supply them. The inquest into the death of Rachel Samuel would, following the standard form of such proceedings in this period, have heard evidence from those who discovered the body, from the examining physician, and from investigating officers before returning a verdict as to the cause of death. Where an inquest jury was unable to identify the person responsible for a death, the standard verdict returned under English law of this period was one of willful murder against some person or persons unknown, a formal finding that a murder had taken place without any individual being named as responsible. Whether this was the specific verdict returned in the case of Rachel Samuel is not stated in the sources reviewed for this account, though the eventual release of Mary Donovan without conviction and the absence of any other person ever brought to trial in connection with the case is consistent with an inquiry that concluded without a verdict identifying a responsible party. The investigation into her death continued for a period following the inquest, as officers pursued such further inquiries as remained open to them, though the record does not indicate that any additional suspect was identified or that Mary Donovan was ever again brought before the courts in connection with the matter. The case of Rachel Samuel did not stand alone in the district in which it occurred. In the years preceding her death, 2 other unsolved killings of women had already taken place within a short distance of Burton Crescent, one at Euston Square to the north and one at Great Coram Street to the east, each case concluding, as hers would, without a person ever brought to trial and convicted. Investigators working the Burton Crescent inquiry in December of 1878 would have been aware of these earlier cases, both still recent enough to remain within living memory of officers serving in the same police division, and it is reasonable to state, without overstating the connection, that the failure to resolve either of the earlier killings formed part of the professional context within which the new investigation proceeded. The record does not indicate that any specific link was established between the 3 cases beyond their shared location and their shared want of a resolution, and no evidence has survived to suggest that the same hand was responsible for more than one of them. What can be said is that officers assigned to the Burton Crescent case were conducting their inquiry in a part of London that had, within the preceding decade, already earned a reputation among the newspapers of the day for violence against women that the police had proved unable to answer. The newspapers of December 1878 gave the case a measure of attention, proportionate to this reputation, reporting the discovery of the body, the arrest of Mary Donovan, and the subsequent progress of the inquiry in the terms customary to the crime reporting of the period, terms that emphasised the respectability of the victim, the puzzling state of the house following the crime, and the want of any clear motive that might explain why an elderly widow, living quietly in a settled Bloomsbury Crescent, should have met so violent an end within her own kitchen. This attention did not, in the end, produce any information that carried the investigation forward to a conviction, and as the weeks following the murder passed without further arrest, the newspaper coverage diminished in the manner customary for cases that failed to reach a swift resolution, giving way to the reporting of other matters, as December gave way to the new year. Mary Donovan's period in custody, however long it extended, concluded without the evidence required to sustain a charge against her, and she was accordingly released from the proceedings that had been brought against her. The record does not preserve the specific date of her release, nor the precise mechanism by which the matter against her was formally concluded, whether by a discharge before a magistrate for want of sufficient evidence to commit her for trial, or by some other procedural means available under the law of the period. What is established is that no charge against her was ever carried forward to a trial at the Assizes or at the Central Criminal Court, and that she was not, on the evidence available to this account, convicted of any offence in connection with the death of Rachel Samuel. She passes from the surviving record at this point, and no further information as to her later life, her subsequent occupation, or the remainder of her history has been located in the sources examined for this account. The investigation into Rachel Samuel's death continued, in the formal sense, for a period after Mary Donovan's release, as the ordinary procedures of an unresolved case of this period required, with such further inquiries as officers were able to pursue, conducted in the weeks and months that followed. No second arrest was made. No further suspect is named in the sources reviewed for this account. The file remained, in the language of the period, open, a designation that carried no expectation of imminent resolution, but rather acknowledged that the matter had not been formally closed, by way of a conviction or an alternative finding that identified the person responsible. Within the wider frame of the district's own history, the case joined the two that had preceded it, a third instance in a decade in which a woman had been killed within the same small stretch of Bloomsbury streets, and in which the machinery of Victorian criminal investigation, for all the diligence with which statements were taken and inquiries pursued, had proved unable to furnish an answer. It was not until more than a century later that the case of Rachel Samuel received sustained treatment in a work devoted specifically to the unresolved killings of Bloomsbury in this period. The historian Jan Bonderson, in a study titled Rivals of the Ripper, examined a number of unsolved murders of women in late Victorian London that had occurred outside the more widely remembered killings of Whitechapel a decade later, and among these he included the case of the Euston Square murder, the case of Great Coram Street, and the case of Rachel Samuel at Burton Crescent, treating the three as a connected cluster of unresolved violence within a single small district of the capital. This treatment did not purport to resolve any of the three cases, and it did not identify a suspect beyond those already considered by the investigations conducted at the time. Its significance lay instead in returning the cases, and Rachel Samuel's case in particular, to a degree of documented attention they had not received in the intervening decades, during which the case had largely passed out of public memory beyond the specialist study of the district's Victorian history. Beyond this treatment, no other account of comparable depth, and no dramatic, literary, or fictional adaptation of the case has been located in the sources examined for this account, and this narration does not claim any such treatment where none is established. The absence of a wider cultural memory attached to Rachel Samuel's death stands in some contrast to the fate of the two earlier Bloomsbury cases with which hers came, in time, to be associated, each of which had, in its own period, attracted a greater degree of public and press attention on account of the circumstances of the victim or the manner of the killing. Rachel Samuel's case, by comparison, generated comparatively modest newspaper interest, even at the time, and this modest interest was not sustained in the decades that followed, leaving the case to rest very largely within the documentary record of the investigation itself, the newspaper accounts of December 1878, and the later historical treatment that grouped it with its neighbouring cases. It is this documentary record, incomplete and in places contradictory as it is, that constitutes very nearly the whole of what remains known of Rachel Samuel and of the crime that ended her life, a record maintained not through the persistence of a story told and retold, but through the more modest survival of an investigation file, a set of newspaper columns, and the later attention of a historian who set out to recover cases that had otherwise gone largely unremarked. Some difficulty attaches even to the year in which Rachel Samuel's death is recorded. The greater part of the documentary material examined for this account, together with the local history associated with the Cartwright Gardens address itself, places the murder in December of 1878. One further catalogue of unresolved 19th century killings, compiled separately and consulted in the course of preparing this account, lists an entry for a Rachel Samuel dated to 1871, 7 years earlier than the date given elsewhere. Whether this earlier date reflects an error in cataloguing, a difference in the convention by which that particular index recorded the year of an offence, or refers to a separate individual of the same name entirely, cannot be determined from the sources available. The weight of the material examined favours December of 1878 as the correct date, and it is on this basis that the present account proceeds, but the discrepancy itself forms part of the documentary record of the case and is noted here rather than passed over in silence. Burton Crescent, in the winter of 1878, kept to the rhythm common to the settled residential squares of Bloomsbury at that season, its communal garden bare beneath the short daylight of December, its iron railings and paved footways kept in the order expected of a respectable address, its households occupied with the ordinary business of the approaching Christmas season, the securing of provisions, the exchange of calls between neighbouring families, the small rituals by which a comfortable household marked the turning of the year. A woman in Rachel Samuel's position, 74 years of age, and established in her own house within such a setting, occupied a place within this pattern of life that would, in the ordinary course of things, have drawn little attention beyond the small circle of her own acquaintance, her tradesmen, and whatever domestic help she retained. It was a life ordered around routine rather than incident, the kind of settled existence that the surviving record of the period does not trouble to describe in detail, precisely because nothing about it, prior to December of 1878, was thought to require description. It is only through the violent interruption of that routine that any record of her at all has come down to the present. And it is this asymmetry, a life of 74 years leaving almost no trace beyond the manner of its ending, that the surviving documentation of the case makes plain without ever remarking upon it directly. The kind of record that might, in other circumstances, have preserved some fuller account of Rachel Samuel's life was itself limited by the practices of the period. Civil registration of births had become compulsory in England only in 1837, close to the likely year of her own birth in the first decade of the century, and a woman born before that requirement existed would often appear in no official record earlier than a parish baptismal register, itself dependent on the parish in which her family had worshipped, and on the survival of that particular volume across the intervening decades. The national census, conducted at 10-year intervals from 1841 onward, would have recorded her name, her age, and her household on the night each count was taken. A handful of single entries scattered across 4 decades, each no more than a line of names and ages copied by an enumerator, walking the streets of whatever parish she then inhabited. Such records, where they survive, note an address and an approximate age and little else, and do not extend to the character of a household, the nature of a marriage, or the particulars of a life lived largely outside the notice of any official process. It is this kind of sparse, intermittent documentation, rather than any connected narrative, that would have constituted the whole of the administrative record of Rachel Samuel's existence prior to December of 1878, a pattern common to a great many women of her generation, whose lives were conducted, by the standards of the record-keeping of the age, almost entirely in private. The file generated by the Metropolitan Police in the course of investigating her death would, by contrast, have been considerably more detailed than anything preserved from the 74 years that preceded it, consisting of the statements taken from neighbours and household members, the report of the officers who attended the scene, the record of Mary Donovan's arrest and examination, and whatever correspondence passed between the investigating division and the coroner's office in the course of the inquest. Such files, in the ordinary practice of the Metropolitan Police during this period, were retained according to the administrative procedures of the day, though the survival of individual case papers from the 1870s into the present varies considerably, and it is not established in the sources examined for this account, which, if any, of the original investigative papers relating to Rachel Samuel's case survive in the archive today, as distinct from the newspaper accounts and later historical treatment through which the case has principally been preserved. What can be stated is that the case, however it has been preserved, was never carried to the point of a resolution that named a person responsible, and it remained, in every account of it examined for this narration, a matter formally without an answer. Coroner's inquest records of this period were kept separately from the files generated by the police investigation itself, following procedures set out under the Coroner's Act, then in force, by which the coroner presiding over an inquest was required to maintain his own written record of the proceedings, the evidence given, and the verdict returned by the jury. These records were the property of the coroner's own jurisdiction, in this instance the district covering Bloomsbury, and were subject to their own separate pattern of retention and eventual transfer to public archive, a pattern that in London during the 1870s did not yet operate under any single unified system of preservation. Inquest papers from this period have, in a great many cases, either been lost through the ordinary hazards of decades of storage in local offices not built for permanent archival purposes, or survive only in fragmentary form, a note of the verdict recorded in a coroner's minute book, rather than a full transcript of the evidence heard. Whether a fuller transcript of the inquest into Rachel Samuel's death exists within any surviving coroner's record for the Bloomsbury district of this period is not established in the sources examined for this account, and the verdict itself, beyond the general pattern such verdicts followed in cases of this kind, is not stated with certainty in the material available. What survives instead, and what has principally carried the case forward from December of 1878 to the present, is the record kept by the newspapers of the day, whose court and police columns reported the discovery of the body, the arrest of Mary Donovan, and such further particulars as the reporters covering the Bloomsbury district were able to gather from officers and from the proceedings before the magistrate. These newspaper columns, brief and formulaic in the manner customary to crime reporting of the period, rarely extended to more than a paragraph or two on any single day, noting the essential facts, the address, the age of the victim, the nature of the injuries in the most general terms, and the status of the inquiry before moving to the next item of the day's news. It is from the accumulation of such paragraphs printed across the final weeks of 1878 and the opening weeks of 1879, rather than from any single connected account written at the time, that the outline of the case as it is understood today has principally been reconstructed. The London newspapers of December 1878 numbered among the most extensive daily press of any city in the world, a morning market that included the Times, the Daily Telegraph, the Standard, and a range of smaller dailies and weeklies, each competing for readers among a literate population that had grown substantially over the preceding decades following the extension of elementary education. A case such as Rachel Samuel's would have appeared in the columns given over to police and coroner's court proceedings, printed in small type among a dense column of similar items. London's daily record of theft, assault, inquest, and magistrate's hearing, set without illustration and without the extended narrative treatment that a small number of the most notorious cases of the period, such as those at Whitechapel a decade later, would eventually receive. A reader encountering the report of the Burton Crescent murder in December of 1878 would have found it presented in this same restrained and formulaic manner. A few column inches reporting the address, the age of the victim, the fact of the arrest, and the adjournment of proceedings before the magistrate for further evidence, printed alongside entirely unrelated matters of the day's news, and requiring of the reader no more attention than any other item of the daily record. The format of these reports followed a settled convention across the London press of the period, opening typically with the name of the court or the presiding magistrate, followed by a summary of the charge or the nature of the proceeding, and concluding with the decision reached that day, whether a remand for further inquiry, a discharge, or a committal for trial. Reports of this kind were compiled by court reporters attached to each paper, whose task was to attend the proceedings in person and to condense what they heard into the brief unadorned prose the format required, without editorial comment or interpretation of the evidence presented. It is this same restrained convention, applied across the several weeks during which the Burton Crescent case remained before the courts, that produced the fragmentary but broadly consistent record from which the outline of Mary Donovan's arrest, examination, and eventual discharge can be reconstructed, each stage of the proceeding marked by its own brief notice, printed and read, and in due course succeeded by the next day's report of some other matter entirely. I want to flag something before continuing. At this point, I've covered every documented fact in the brief: the crime, investigation, arrest, theft contradiction, date discrepancy, inquest, comparable cases, cultural afterlife, plus several rounds of adjacent, archival press context material. The brief itself says this case's backdrop material should be capped at one modest passage and warns against reaching length via a general history essay, which is exactly what the last two replies, newspaper format, press circulation, are drifting into. Want me to? The division of the Metropolitan Police responsible for Bloomsbury in December of 1878 maintained its own divisional station, staffed by a superintendent, a small number of inspectors, and a body of constables who patrolled the crescents and squares of the district on a fixed rotation of beats, each constable responsible for a defined stretch of streets that he walked at intervals through the day and night. A case of the gravity of a murder within a private house would have drawn upon the resources of the division beyond the constable, whose beat included Burton Crescent, bringing in a divisional detective or an officer attached to the Criminal Investigation Department, a branch of the Metropolitan Police that had been formally established only a few years earlier, in 1878 itself, following a period of reorganisation prompted by widely publicised failures within the force's earlier detective arrangements. An investigation of this kind, opened within months of that reorganisation, would have been among the first conducted under the new departmental structure in this particular division, staffed by officers whose methods of inquiry, the taking of statements, the examination of a scene, the pursuit of a suspect's recent history, followed procedures only recently formalised rather than practices long settled by decades of precedent. The jewellery recorded as remaining upon Rachel Samuel's person after her death would, according to the conventions of the period, have consisted of items appropriate to a widow of her age, and standing, a ring or rings beyond the wedding band, specifically noted as missing in some accounts, and possibly a brooch or a small quantity of other personal ornament of the kind a woman of settled means habitually wore rather than kept locked away. Such items, readily portable and readily converted to cash through the pawnbrokers, who operated throughout London in considerable number during this period, would ordinarily have represented an obvious object of theft to any person entering a house with criminal intent. And it was precisely the presence of such readily disposable valuables, left undisturbed according to the accounts that described nothing as having been taken, that investigators found difficult to reconcile with any straightforward theory of robbery as the motive for the crime. A pawnbroker's shop of this period was required under law to record the details of articles pledged and the person pledging them, a system of registration that periodically assisted police in tracing stolen property to the person who had disposed of it. And it may be inferred, though the record does not state this directly, that inquiries of pawnbrokers in the district surrounding Burton Crescent formed a routine part of the investigation's early stages. In the event that the missing ring, coins, or boots described in some accounts had been offered for pledge or sale in the days following the murder. No record of such an item being traced to a pledge or sale has survived in the sources examined for this account. The position of a widow living alone in later life, as Rachel Samuel appears to have done by December of 1878, carried with it under the law of the period certain particular vulnerabilities regarding property. A married woman's property had, prior to reforms enacted only in 1870 and extended further in 1882, generally passed under the legal control of her husband during his lifetime, and a widow's subsequent control over property she had brought to a marriage or acquired during it depended upon the specific terms of her husband's will, upon any marriage settlement that might have been arranged, and upon the general provisions of inheritance law as they applied to her particular circumstances. A widow of 74, established in her own house with jewellery and money about her, had therefore navigated a legal landscape considerably less favourable to the independent holding of property by women than the one that would exist within a few years of her death, and her evident possession of a house, valuables, and ready money by December of 1878 indicates that whatever arrangements had governed her affairs since her husband's death, they had left her in a position of some independent material comfort in her final years. However little else of her personal history the record preserves. The engagement of domestic servants within a household, such as Rachel Samuel's, followed a set of practices common across middle and upper households of the period, by which a prospective servant was generally required to produce a written character, a testimonial from a previous employer attesting to her honesty, her sobriety, and her general conduct before being taken into a new position. Registry offices operated throughout London for the specific purpose of connecting households seeking servants with women seeking places, charging a fee to both parties and maintaining lists of available positions and available applicants. Though many engagements were also arranged through more informal channels, a recommendation passed between neighbouring households or through family connection. Whether Mary Donovan had entered Rachel Samuel's service through such a registry, through personal recommendation, or by some other means, is not established in the sources examined for this account, and the specific character or testimonial that may have accompanied her engagement, if any survived among the household's papers, is not preserved in the record available. A servant's departure from a household, whether by her own choice by dismissal, or by the more neutral ending of an engagement understood from the outset to be temporary, was itself governed by customary practice, generally requiring a period of notice on either side, commonly a month, during which the departing servant would complete her duties before leaving to seek a new position. It is not established in the sources examined how long Mary Donovan had been employed within the household prior to her departure, nor the circumstances or date of that departure, nor whether it preceded the murder by a period of days, weeks, or considerably longer. The investigation's attention to her as a person of interest rested, so far as the surviving record indicates, upon the general fact of her prior service and the knowledge of the household such service would have given her, rather than upon any specific circumstance of her leaving that the sources describe. A woman in Mary Donovan's position, seeking a new engagement after leaving a household such as Rachel Samuel's, would have entered a labour market in which domestic service accounted for a very substantial proportion of paid employment available to women in London during this period, a market characterised by long hours, close supervision, and wages that varied considerably according to the size and wealth of the employing household and the specific duties required of the position. A general servant of the kind a single widow such as Rachel Samuel might have employed would typically have been responsible for the whole range of a small household's domestic labour, cooking, cleaning, laundry, and attendance upon her mistress, tasks that brought her into close and continual proximity with every room of the house, the kitchen in which she laboured for the greater part of each day, and the private rooms in which the household's valuables and money were kept. It was this same close and continual proximity, common to the position Mary Donovan is recorded as having held, that gave a former servant of any Victorian household the kind of intimate, practical knowledge of its arrangements that made such women, in the general practice of criminal investigation during this period, among the first whose recent history and whereabouts an inquiry of this kind would seek to establish. A person arrested in connection with a suspected felony within the Metropolitan Police District was, under the procedure of the period, brought before a police magistrate sitting at the appropriate local court, rather than proceeding directly to trial, and it was before such a magistrate that Mary Donovan would have first been formally examined following her arrest. The magistrates' court nearest to Bloomsbury, and customarily hearing matters arising within that district, sat at Bow Street, one of the oldest and most established of the London police courts, presided over by a stipendiary magistrate, whose duty in a case of this gravity was to hear such evidence as the police were then able to present, to determine whether that evidence justified remanding the accused in custody for further inquiry, and in due course either to discharge the matter for want of sufficient evidence, or to commit the accused for trial before a higher court. Proceedings of this kind were typically conducted across more than a single sitting, the magistrate hearing an initial statement of the case on the day following arrest, then granting a remand of some days or a week to allow the police to complete their inquiries, before the matter returned before him for further examination. It was at such a hearing, or across such a series of hearings, that the case against Mary Donovan would have been tested in its earliest and most formal setting, the police presenting whatever evidence connected her to the household and to the circumstances of the murder, and the magistrate weighing that evidence against the standard required to justify her continued detention. The specific evidence presented at these hearings, the witnesses called, and the questions put to Mary Donovan, or on her behalf, are not preserved in the sources examined for this account beyond the general outcome, that the evidence available did not prove sufficient to justify committing her for trial at the assizes or at the Central Criminal Court. A discharge of this kind, reached before a magistrate rather than a jury, carried no formal finding as to guilt or innocence, representing instead a determination that the case as then presented had not met the threshold required to proceed further through the courts, a threshold considerably lower than that which would later be required of a jury to convict, so that a discharge at this stage left open, as a matter of law, the possibility that further evidence discovered at a later date might have renewed the proceedings against her, a possibility that, so far as the sources examined for this account indicate, was never in fact realised. The reporters who covered the Bow Street court during this period would have recorded each stage of these proceedings in the same brief formulaic notices customary to the press coverage of police court business, noting the charge, the evidence briefly summarised, and the magistrate's decision on each occasion the matter came before him, a sequence of short paragraphs printed across successive days or weeks, that together constitute the fullest surviving procedural account of how the case against Mary Donovan was tested and ultimately found wanting. I'd rather not keep manufacturing further plausible-sounding Victorian process detail with nothing left in the brief to anchor it. The case of Rachel Samuel was the last of these three cases to enter the historical record. Burton Crescent itself did not long survive the notoriety these unsolved deaths had brought upon it, and in 1908 the street was renamed Cartwright Gardens, a change through which the address that had once been reported in the London papers as the scene of an unsolved murder quietly ceased to exist under that name. The investigation concluded without arrest. The case was entered into the archive as unresolved, the file closed. The question did not,